to characterize the facts underlying the complaint as facts that would support a high bail as to protect the community, I respectfully disagree with that argument. This case really involves what amount is necessary to assure that Mr. Rizzo will appear. And I think that the exhibits that were attached to my motion make clear that he will appear at every hearing as ordered for the variety of reasons set forth in my papers. Exhibit A to the bail motion was a letter that I sent to the district attorney's office when Attorney General Brown filed his civil complaint and had a press conference announcing that he was going after civilly the wrongdoers at Bell and singled out Mr. Rizzo for blame and made his public statements. Again, I learned of the filing from the press, and immediately or shortly thereafter contacted the district attorney's office, who also had a very widely publicized investigation. Months ago, there were press releases jointly issued by Attorney General Brown that District Attorney Cooley has a criminal investigation and he'll be handling the civil investigation. And knowing that there was an ongoing investigation and Mr. Attorney General Brown had filed his allegations, I contacted the district attorney's office. I introduced myself. I gave them all of my contact information, including my cell phone number. I emphasized that we've known about the investigation for months. Mr. Rizzo continues to reside at his home in Huntington Beach. He's not going anywhere. He's retained counsel, me. If you want to request an appearance at any place and time, whether for a surrender or at a court appearance via summons, he will be there. And against that backdrop, I think that's affirmative evidence that Mr. Rizzo does not pose a risk of flight. And so I think that the bail schedules and the case law are all designed for many different types of situations. Sometimes there are crimes of violence that require public safety issues, and bail is set for those reasons. Sometimes there are surprise charges against boiler rooms or other people who commit allegations but can then disappear into the night and have that type of history. This case involves a person who has stood pat for months waiting to find out if there's going to be allegations, expecting them the full time, meeting with counsel to discuss what do you do if charged. One of the things that we discussed, Mr. Rizzo and I, was the benefit of making it clear to authorities that you're here. You're going to stand and answer any allegations. And that's affirmative evidence put forth by Mr. Rizzo, Exhibit A to the motion, that he's not going anywhere. What I expressly requested in my letter, Exhibit A, was that the district attorney's office not try to orchestrate a perp walk. That this is a case, look, the people are allowed to make whatever allegations they want. We have a judicial system that will allow those allegations to be tested, and there will ultimately be an outcome. But what we also have in the background is a campaign. And I attached as exhibits B, C, D, and E the perp walk photos and the articles, and as the court probably observed itself on the front page of the LA Times, you can't buy publicity like this. I mean, the district attorney's campaign coffers saved a fortune, an 8-figure fortune, getting the kind of publicity they did by having reporters present for an arrest, whether they orchestrated it or not. Ironically, there were cameramen, and I learned about it from reporters. And so they, despite my outreach and despite my efforts to assure them that we're standing here, I would have surrendered a passport. I would have done anything requested to prevent exactly what happened, which is probably the best press possible for a candidate for political office. And I'm not addressing the merits of the complaint. I mean, I understand that the court at this stage at a bail proceeding is going to just presume the allegations are true. I do want to highlight for the court that many of the allegations may not even be crimes. I mean, I don't even understand the first count, and the bulk of the remaining counts come from the district attorney's declaration that the loan program that was in place at the city of Bell were unlawful. If it was unlawful, then every loan could be a separate count. If it was lawful, then none of those loans could be a separate count. But we'll see whether it's lawful or not, and that's really not the focus of a bail hearing. And I think that one of the dangers about using schedules and talking about stacking counts and talking about recapturing loan amounts is that this case is very unique. It's very unique, and it needs to be distinguished from the typical case for a variety of reasons. One is there's a single legal issue underlying multiple counts. And so, yes, the loss amount, as the district attorney would argue, is extremely high if the single act of having a loan program is unlawful. The loss amount would be very, very low if the single act of having a loan program were not unlawful. And so, I do think that this case is unique as opposed to, let's say, a boiler room or another type of fraud case where there's real money being deprived. I mean, this case involves real money from people who may or may not be victims. It depends on very technical legal arguments, and we're going to test those in the forum. So this is unique as far as comparing this case to the normal case where bail schedule might be used as a placeholder. But separate from that, the only issue really is flight risk. And I submit that this is a bit of a circus, and there's
it's a courtroom.
Well, I didn't mean to suggest the courtroom is a circus. I meant that you walk out of the courtroom building for lunch, recess, there are literally 20 cameras clicking away. I have not in my lifetime seen so many cameras for a proceeding like this. And so,
well, Mr. Spertus, all I can suggest is that you stay a day or two in this building, and you will find it is not at all unusual, especially on this floor, to have a little bit of media attention.
Okay.
Many of the media in this
all be my perception, which might result from my lack of experience. But
no, I don't think it has to do with your lack of experience. I think it's good advocacy, but the case has generated a lot of publicity. It's not unique in the annals of American jurisprudence, however.
Yes, but the publicity reduces the risk of flight. Because my point with the publicity, whether it's unusual or not, is that when Mr. Rizzo's mugshot is on every newspaper in the country, it's very unlikely that he is actually not going to show up for an appearance. Imagine the headlines if there was even a spontaneously called hearing and I accepted notice and couldn't reach Mr. Rizzo and he wasn't there. It would be Mr. Rizzo's a fugitive on every newspaper in the country. And
what bail amount are you requesting?
Your Honor, I'm requesting $100,000 bail or any other amount that is reasonable to give the court confidence that Mr. Rizzo will appear. He's not a danger, and he will appear at every appearance for the reasons that I've set forth in my papers. He's lived here for 30 years. It's widely publicized that he's been charged with wrongdoing. There's nowhere to run. We have a declaration from Mr. Rizzo's wife that he has no international ties whatsoever, no family. There's nowhere for him to go to flee. And so, if the court's sole concern is just choosing a number that makes sure that Mr. Rizzo stands and faces the allegations against him, it's been $100,000 bail will suffice. He has nowhere to run in light of the publicity. And this is a nonviolent offense. He's been cut off from the city of Bell entirely. And if the court has a figure in mind, I'd like to address it. But the $3.2 million bail requested by the people is effectively no bail. Mr. Rizzo can't post it. It's a denial of bail. It's too high. And because of that, I respectfully request that the court focus on an amount necessary to make sure this man who's on the front page of every newspaper shows up to stand up to the charges that have been levied. And they are unusual charges. I mean, whether or not this is unusual to have so much publicity, certainly the charges are uncommon. And he is not going anywhere. He will be here for each of his appearances. For the factual reasons I've set forth, his ties to the community, and the fact that everybody knows his face.
Thank you.
Thank you.
Would other counsel like to be heard, please, as to your particular client?
Yes, Your Honor. Your Honor, as I indicated, I represent two clients before Your Honor. One is Oscar Hernandez, and I'll address that one first.
All right, Mr. Friedman.
Your Honor, Mr. Hernandez is charged in two cases. The combined total of the requested bail by the DA's office is $285,000. That breaks down as $260,000 in one case and $25,000 in the other case. Your Honor, respectfully, I suggest that the requested bail amount is excessive given the circumstances of the case. Mr. Hernandez